Okay, we'll get started. Welcome everybody to this presentation. This is related to the Incorporated Societies Act of 2022, which you'll be familiar with, passed earlier this year. And more specifically today, we're going to be talking about the very recently launched public consultation on the regulations that will complement that act. I'm going to talk you through the contents of today's presentation. Just to give you an overview, a few signposts. But first, I'll just tell you who I am. I'm Robert Clark. I'm currently acting as the Principal Policy Advisor in the Corporate Governance Policy team at MB. And I'll be the only voice you hear today from this point on. I am ably assisted, though, by Annie McGuinness, a policy advisor in my team, who will be sorting through the Q&A so that when we come to the end of this presentation, she'll have chosen a few of the questions that I can attempt to answer today. Please type those in the Q&A section rather than the chat section. We won't be checking the chat section. If I'm unable to answer all the questions, which is very likely, then what we will do is try to circulate afterwards along with the slides. Post to the company's office web page. The slides from this presentation, a recording of this presentation and a transcript, but also a document with your questions and some written answers. So the contents of today's presentation. First, I'm going to talk to you about the project timeline. And by project, what I mean is this work that we're doing on developing regulations to supplement the Incorporated Societies Act. Then I'm going to talk to you about the structure of the discussion document that we published recently, and some of you will have taken a look at it. Then the next two areas I'm going to look at in today's presentation, I've put them in red because these are the only parts of the presentation that actually, in which I'll actually be talking about the proposals in that discussion document. I'll first talk to you about parts 2 and 3 of the discussion document. There are 4 parts in that discussion document. Parts 2 and 3 are really all about the rules that will apply once you've re-registered. So the new rules of the game. Part 4 is about the rules that will apply as you're preparing to re-register. So just a reminder, we have the board rules in the Act already. The board rules on how you will need to organise your society once you've re-registered. But in parts 2 and 3 of the discussion document, we look at filling in some of the details. Apologies for that. As I was saying, in the Act, we've already got some high-level rules on how a society will need to be organised. But in parts 2 and 3 of the discussion document, we're going to be looking at some proposals on some finer details that the regulations will have to supplement those broad provisions in the Act. And the same for part 4, we already have in the Act some provisions on how a society will go about re-registering, but there are a few details that need to be filled in. After that, I'll take a look at next steps. That's really just a more detailed version of the project timeline. And then we'll get to the questions which have been piling in. Already got 47, although some of those were about the microphone. Oh, yes, please move the mic up. Looks like it's all going now. Just like to start with the opening karakia from MB. Tawhia tō mana kia mau kia maia, ka huri taku aro ki te pai ka horangi, ke reira te aranga moku, ma mahi tahi, ko ka ora, ka puawai, a mātou mahi katoa, ka pono, ka tika tihei, Māori ora. I won't translate it all for you, just the last couple of lines. By working together, we will flourish and achieve greatness, taking responsibility to commit to do things right. So that's what we're here to do today. Oh, apologies. So here we are at the project timeline. You'll see in the blue bubble on the left, April 2022, that's when the new Act was passed. In that Act, as I said, some of the broader rules were set. For example, you'll only need 10 members in future, you won't need 15. You won't need to have a seal anymore, so you can throw out those rubber stamps. On the other hand, you will need to start putting into your constitutions procedures for settling internal disputes. So it's a bit of a good news, bad news story in terms of the amount of work you might have to do. In the bubble on the right in lime green, you'll see that from October 2023 to April 2026, there is a re-registration period open under the new Act. That's for 2.5 years. So at any time during that period, your society will be able to choose to re-register, and at that point of re-registration, you'll switch from being governed by the 1908 Act to being governed by the 2022 Act. So what are we here for today? It's to discuss the bubble in the middle, which is in green, dark green. So since about May, just after the Act was passed, and until September next year, we're working on regulations to support the new Act. Moving on to the structure of the discussion document. So it has 4 parts. Part 1 is just an introduction. Sets out the context, talks about the Act and how the Act is very good, but obviously Parliament can't decide every single little detail, and so some of those details have to be consulted on with the public and set out in regulations. Then, as I mentioned, parts 2 and 3, those are about regulations that apply once your society has re-registered. So it's the new regime. Just in case you're interested, part 2 focuses on the substantive rules that will apply, and part 3 is about the fees that might need to be charged associated with the functions of the registrar or the Companies Office to run this new regime. Then part 4 is about the regulations that apply to a society preparing its application for re-registration. So, for example, what sort of things do you need to put in your re-registration application? So we'll get cracking with parts 2 and 3. Just a reminder, regulations, these concern regulations that apply once a society has re-registered. So first up, got a couple of slides on these parts, but first up, these parts seek feedback on what I generously call lots of procedural matters, although mundane has been mentioned as well. Examples include the level of late fees. So, for example, if you are late providing your financial reports, which the Act says you have to send in within 6 months of your balance date or the end of your financial year, then the discussion document in part 3 proposes a fine of $25 if you are up to about 20 days late. After that, it's a fine of $100. Those are one-off fines, and they're called late fees because, in fact, they're not designed to punish you. They're designed to help the Companies Office recoup the costs of sending you a reminder notice, that sort of thing. Then we get to the level of actual fines. These aren't designed to recoup costs that the Companies Office might incur. These are designed to deter people from avoiding their obligations and to punish them if they do avoid their obligations. So an example of the fines proposed in the discussion document, if you fail to send in your financial statements, there is the possibility of a fine of $500. Now, I must stress that the Companies Office will be focusing on education early on, so don't immediately think that you'll be slapped with a fine if you're running a few days late. And they have what's called prosecutorial discretion, which means that they don't actually have to fine you for these things, but and in the early years, I imagine they'll give quite a lot of flexibility. Just for comparison, under the 1908 Act, if you're late with your filing of annual financial statements, you're currently subject to a fine of $1 a day, a shilling being about 10 cents. I'm not sure if that has been enforced for quite some time. More procedural matters, things like if the registrar does decide to fine you, what should be in the notice, the fine letter that they send you. So it's going to say the nature of the offence they allege you committed, the way you can pay your fine, and how you can appeal. And then how people can serve documents on a society or an officer. So pretty fascinating stuff. This is about for example, if you have a legal document and you want it to be served on an incorporated society like you, should they have to bring it to you physically, or can they send it by email to your contact officer or contact person, things like that. And if you're still awake, another procedural matter, there's this term current assets, which is used in the Act, and it is essentially accountants speak for liquid assets, which is basically what you've got in your bank account. It's important in the Act because it's used to help define which societies are small societies, and small societies are lucky because when they prepare their financial statements, they won't have to use the fancy standards laid down by the External Reporting Board. So it's good to be a small society. But the Act doesn't say precisely or define precisely what current assets means. So there's a discussion in the consultation document about that, and we'd be interested in your feedback. Now, that's the procedural stuff. There's also a few meaty issues which you might want to focus on if they're important to you as a society. So one of the issues is about the definition of officer. So the people who are officers under the Act, they have certain duties. For example, to act in the best interests of the society. And the interesting thing is the definition of officer in Section 5 of the Act says it's anyone on the committee, it's anyone with a position basically of authority, such as a treasurer or the CEO if you're a big society. But it also is anyone specifically included by regulations, or anyone, or excludes anyone specifically excluded by regulations. So if you think there is a category of persons who should be expressly excluded from being officers, even though, for example, they may happen to sit on the committee or be the treasurer or the CEO, then that's something you might want to submit on. There's a rule in Section 45 of the Act which says that on your committee, the majority of members have to be members of the society, which is a new rule, but it is possible under regulations to create exceptions to that. And in our discussion document, we put forward some ideas on possible exceptions, notably some of the national sporting bodies, where past reports have really indicated that for the well-being of sports people, there needs to be a fully independent committee. You may have other ideas for other types of society. This next one's quite a topic of conversation sometimes. If you're an incorporated society that's a registered charity, you will already know that you have to have your financial statements audited if you spend more than $1.1 million per year. And so we had to decide, well, if you're an incorporated society which is not a registered charity, what should the threshold be for when you need to have your financial statements audited? And you'll see that after a lot of analysis required by the Act, we came to the conclusion that should be if you spend more than $3 million per year. So those is getting to pretty big incorporated societies at that stage. Finally, there's a discussion about eligibility to be an officer. So the Act provides for the possibility of regulations saying that if someone's banned in an overseas jurisdiction, they should be ineligible to be an officer in New Zealand. That is to say, if they're banned from being on a committee abroad. In the discussion document, we say, yes, that's correct if they're banned in Australia, but we haven't suggested that bans in other jurisdictions, other countries should disqualify you. You may think that's not going far enough, or alternatively, you may think that it's going too far, and that overseas bans shouldn't be relevant. So let us know. Perhaps you think that somebody who's banned in the UK, for example, should also be banned from being an officer in New Zealand. So part 4, just a reminder, that's about regulations that apply to a society preparing its application for re-registration. So this is before you re-register. This part of the discussion document seeks feedback on things like what information should be included in a re-registration application. So not particularly exciting, but we say things like, well, you've got to provide the name of your society, copy of your fresh constitution if it needs refreshing to meet the requirements of the new Act, your NZBN number, maybe your balance date, things like that. This is a bit more interesting. We're asking your view on whether there should be a fee for re-registration. So obviously, re-registering 24,000 incorporated societies will generate some costs. People have to be paid to process these re-registration applications. We don't say in the discussion document whether we think incorporated societies should chip in. If you were asked to, it'd probably be about $50, including GST. So we just ask for your views. And some of you may know that even if you miss the deadline of April 2026 to re-register, there is a process for restoration. Unlike re-registration, we do know that there will be a restoration fee and be higher than $50. So you do want to try and re-register by April 2026. But in the discussion document, we ask about what an application for restoration should look like. So making a submission. Bubble down the bottom, consultation is open from 11th of October to 22nd of November. We do know that you may be very busy because you're out there doing God's work, teaching people to play sport and looking after our national monuments. So don't despair if that time frame is difficult for you. We do understand, and we will be looking at submissions that come in late. It's just that the best way to have your say, I think, is to get in early. It's just human nature that we'll be forming our views as we read. So it may be best the earlier you can get in. A few points on making a submission. A template is available, just a Word document with a few boxes in it, and you can type your answers into each box. Each box relates to a specific question. You don't have to use the template. It'd be good if you can think of real world examples from your society when you're arguing for a point. So you might say, well, our society had a chap start as a director, and we found out that he was banned in the USA, and he ended up causing all sorts of trouble, and would have been a good thing if bans from the USA had meant he was ineligible in the first place. So those sorts of real world examples can be quite helpful for us here in Wellington, just to understand your position better and to convince our minister of the merits of any particular argument. Do try to be balanced. It's often good to try to anticipate how somebody might try to counter your argument, and then to think about why their argument in turn might not stack up. And if you want to just focus on a few of the questions. No need to answer all the questions. We know there are quite a lot. Okay, next steps. Got a few dates here. 11th of October to the 22nd of November, 2022. So this is the period, of course, where we're doing our consultation on what should be in the regulations. And we call that high level because in April and May, we'll be doing a much more detailed consultation. We'll actually publish a draft version of the regulations. Now, that might not be everybody's cup of tea because it'll be written in a legalistic way, but it'll give you a second bite at the cherry if you don't like where we've landed. Then in September 2023, we'll be publishing, well, the Minister, or as the Governor General actually, will be making the regulations final. And 28 days later, in October 2023, societies can start applying to re-register. If you've got some specific questions about the regulations, you can send those, or the proposed regulations in our discussion document, you can send those to societies@mb.govt.nz, and either Robert or Annie will respond to you promptly. Now, if you have specific questions for the Companies Office, otherwise known as the Registrar of Incorporated Societies, they can be sent to engage@societies.govt.nz. So that includes anything about education campaigns. Where can you find some more information? This webpage is pretty useful. I usually find it by typing Companies Office Incorporated Societies into Google, and this is the first result you get. And on that page, you'll see there's a section called Law Changes for Societies, and that has lots of useful information put together by the Companies Office team, all about what's going on in terms of the Act. A lot of your questions that you've asked will be answered there. Also talks about the discussion document that's come out just recently. Oh, Derek has come up with a question. Where do we find the discussion document? Well, that's interesting. We emailed out a link to the discussion document to a lot of people. Perhaps some people haven't been on those distribution lists. I think the best thing to do, Derek, if you want a copy, just email us at societies@mbie.govt.nz, and we can send you a link to it. Otherwise, there is a link to the consultation on this page here that the Companies Office has listed law changes for societies, so you can go there.